Welcome to Workplace Wake Up, your go-to podcast for practical employment law guidance. I'm Jennifer Shaw, the founder of Shaw Law Group, and I'm here to help HR professionals and leaders navigate the legal minefield of the modern workplace. Each week, we tackle real-world issues with clear advice and a little tough love. Let's get started. We're having really nice weather in Sacramento. I hope you're having good weather where you are. Spring is coming. That's all there is to it. My flowers are starting to come up. I'm very happy. So I'm really happy to tell you that Joe Beachboard is back with us. Hi, Joe. How are you?
I'm doing great. Thanks for having me back on a Workplace Wake Up.
Well, I'm so happy to have you here. And you guys, Joe and I had so much fun last week. We co-presented on the Employers Lawyer Key Employment Law Update for 2026. So we talked about all of the legal developments for 2026. We had amazing attendance, such positive feedback. And most importantly, Joe, we gave a little back to the HR community. We did that for free. I loved it. It felt really good. And I love doing it with you.
Well, it was a wonderful experience. You and I have had the pleasure of presenting together many times, and it just seems to get better. And last week's program was probably my favorite that we've done.
You know, I thought so too. I really love it when we put on our advisor hat and we think about, okay, how can we make their jobs easier? Because HR is tough, right? There's so much going on, so many expectations. And I always feel like there's this tendency of leadership and management to think of HR as being the fix-it, the cleanup crew, right? Like, we made a big mistake. HR's got to go fix it. Well, sometimes you can't unwind the things that happened, right? It's so much better to use HR more as a preventive approach, as a tool to make sure we're doing things correctly as things are happening, and not so much as, we made a mistake, we need to fix it.
Yeah, and that's a big part of Employers Lawyer, right? I mean, that's really the underlying principle that you and I have embraced as part of that. And certainly that was the approach that we took in the webinar last week. So I hope everybody was able to attend and see our fancy studio.
I know, I love our studio. I love our studio. And by the way, if you missed it, it is on our website. So you can go on the website and you can find it there. There's lots of good information for you. So today we're going to do something a little bit different. Joe and I are going to give you our top 10 California employer wake-up calls for 2026, a little bit David Letterman style. I know some of you who are listening to the podcast may not even know who David Letterman is. I don't know. I was told that by somebody who works in our firm the other day. Jen, not everybody knows who David Letterman is. Okay, well, I hope that's not true. But anyway, he's fantastic, and we want to do a little countdown. So, Joe, you're going to start with number 10 on our list.
Yes, indeed. And this kind of falls into the category of be careful what you ask for. Number 10 is the ruling from the U.S. Supreme Court regarding nationwide injunctions. For a long time, there's been a concern about judges in one jurisdiction being able to issue an order that would stop or require a certain action all across the country. And employers aren't the only one who had concerns with this. Obviously, the U.S. government did as well, because one judge could stop an entire policy action or a guidance implementation, as we saw a couple of times in the wage and hour area. So this got all the way up to the U.S. Supreme Court on whether or not one judge can issue a nationwide injunction. And the U.S. Supreme Court ruled that they can't, and basically said that an individual federal court judge cannot issue a nationwide injunction. Well, the result of that is, well, great, you have one judge that can't issue a ruling that's going to cover the entire country, but instead you're going to have 100 judges in 100 different jurisdictions interpreting the rules and the laws differently. And it's going to become even more challenging, I think, for employers in some cases to deal with these issues. Any thoughts on that, Jen?
I think that's absolutely right. And it just doesn't make logical sense to me. I mean, I understand that the Supreme Court is interpreting the law. So if this wasn't set up appropriately for the court, then Congress needs to make a change. It just doesn't make sense. I mean, we need clarity. We don't need confusion in the HR community. That is what we got, and that is number 10 on our top 10 list. Now, number 9 is about payroll. Payroll just got a lot more complicated when it comes to the One Big Beautiful Bill Act. So many of you have, I'm sure, been struggling with, how do I give my employees the information they need to take the tip exemption and the overtime exemption? For 2025, the IRS has said, listen, we didn't give you enough notice. This law didn't come into play till April. It's okay. Do what you can do. Give the employees the help you can so they can try to get these exemptions. But for 2026, we've got to do this right. And there's a couple of little sticking points here. One of them is on the overtime. Remember, this is a federal law. And under the Federal Fair Labor Standards Act, we only pay employees weekly overtime. California requires the payment of daily overtime and double time. So when we talk about the exemption for overtime, we're only talking about the federal overtime, the weekly overtime. So you or your trustee payroll company has to find a way to look at the overall overtime and figure out how to make sure what was weekly overtime. That's the amount you're going to be putting in box 14 of your W-2 for 2026. You're not going to give your employees tax advice. I've run into a lot of our clients who want to explain a little too much about what this law actually did and how these exemptions work. But you do have to provide some information. I think the lesson for employers is payroll coordination is now a legal compliance issue, as if it wasn't before, right? The wage statements, making sure that we're showing in California the regular rate of pay appropriately. I mean, we could talk about that for 3 days. But the idea is payroll is becoming more and more complex. You don't just throw the former receptionist into the payroll job and say, okay, take it and run. And you also don't just blindly hire a big payroll company that may not be focusing on California compliance issues. It really is caveat emptor here. You've got to be careful about what you're doing and how you're doing it. Okay, number 8, Joe, and some of you probably are noticing this podcast is going to go a little more than 15 minutes, and I think you'll be okay with that because you're getting a bunch of good information. All right, number 8, Joe, we got to talk about independent contractors.
Yeah, this builds on what Jen was just talking about in terms of federal changes, and my warning to all of you that don't necessarily believe what you hear from the feds is going to change what the expectations are here in California. And independent contractors are an area in which that advice is especially important. You're going to hear continuing comments from the federal government that we're going to make it easier for employers to hire independent contractors. Well, that's great, except if you're in California, where we already have the ABC test, which makes it virtually impossible to lawfully hire independent contractors in the state of California. So remember, no matter what you hear about the federal standard easing, we still have to abide by the ABC standard, and it's going to be very, very difficult to actually accurately classify somebody as an independent contractor. Don't make that mistake.
Well, and I have to say, Joe, some clients are going kicking and screaming on this one. They just can't get over this idea that if Joe wants to be an independent contractor and I want him to be an independent contractor, why in the heck can't we do that? And it's because the government misses revenue when you do that, right? There's a financial consequence to the government when you have people classified as contractors and not as employees. So keep that in mind. All right. Number 7, the minimum wage is increasing. Again, difference between federal and state. In California, for most of our employees, the minimum wage is $16.90. If you think about exempt employees under the white collar exemptions, the administrative, the professional, and the executive exemptions, that's about $70,304 to be exempt. That has to be a fixed salary that is not subject to variation based on the quantity or the quality of the work. Now, there are some special rules for things like healthcare employees, restaurant employees. We've got also in Los Angeles, where Joe is located, the Olympic minimum wage, which eventually, by the time the Olympics are held in LA, will get that minimum wage up to $30 an hour. So there's a lot going on here in terms of minimum wage. also remember you have local cities and counties that have their own minimum wages. So if you have non-exempt employees who are traveling between locations, maybe they are in Berkeley one day and then they go to San Francisco and San Jose and Emeryville and Oakland, you may have different minimum wages. So you got to figure out how to do that. There are various things that have to be paid at the minimum wage, including things like shift differentials. You can pay them at a higher rate if you want to, but you have to at least pay minimum wage. Okay, number 6, Joe. All right, we're back to pay issues, pay data.
Yeah, well, first of all, if you have less than 100 employees, you can take a momentary mental break because you won't be covered under this particular provision. But those of you over 100 employees know that it is a requirement in California that each year you provide certain information about your employees, including now information about their pay. It was mainly about demographics previously, and they're now also incorporating a pay requirement into this as well. Well, Jen, you and I could talk for a whole episode about the frustrations that employers have associated with trying to comply with this California requirement. But in the past, it was sort of like, well, you do your best, and if you don't get it right, okay, no big deal because there's no penalty. Well, that's changing too. So now there's more obligations and there are potential penalties if you don't file or you don't file appropriately. So make sure you're doing it. Get them in on time. They have to be in by May, and you want to make sure you check this one off your list.
Get it done. Absolutely. All right. Number 5 is about good faith. And good faith actually requires you all to do homework. Here's what I mean. When we talk about wage hour violations or other violations, there's this concept of, I was a good employer. I wanted to do the right thing. I cared about my employees. I didn't know that they were owed daily overtime. I thought I could just pay weekly overtime. So can't you let me off the hook for paying that daily overtime? And the court is going to say, no. You have to have tried to understand what the law is. Now, overtime is a silly example. Everybody knows in California, you've got to pay your overtime for daily for more than 8 hours in a workday. But when you think about some of the things that come up, and pay data reporting, for example, as Joe just talked about, if you don't do your homework and understand what the laws are, you don't get to just plead ignorance. You don't get to just say, oh, final pay is due on the last day of employment. If I fire somebody, well, I thought I had 72 hours. So I'm sorry that I was late. Do I still owe waiting time penalties under Labor Code Section 203? Yes, you do, because it's obvious that you paid late and nobody hid the rule there. You got to make sure that you were paying somebody appropriately. Now, if there's a misunderstanding about, well, I thought they quit, so I thought I had 3 days. I didn't fire them. I don't know why they thought they were fired. Okay, that's a misunderstanding. You may have had a good faith reason for not processing that payroll in time. But the court has made clear here in California that you've got to do your homework. You can't just close your eyes and plug your ears and hope for the best. You have to go out there, find the answers. This is why you need HR people who know what they're doing, who can be trained, who can understand what's going on. Again, Joe, that's employer's lawyer, right? Making sure that we are giving our HR folks, our managers, our leaders, the information that they need. Okay, so Joe, let's look at number 4 on the list, DEI. Is it dead? What's going on with DEI these days?
Well, that's a great question, Jen, but there's been such a radical change in the interpretation of some of our discrimination laws that it has driven employers to really question how much risk are they taking by having a DEI policy. And this all goes back in many ways to the Ames versus Ohio decision that was issued by the Supreme Court last summer, and a finding that, in fact, there is no such thing as reverse discrimination. There's only discrimination. It's the same burden of proof, whether you're a member of the majority or you're a member of a minority. And this has then led federal agencies like the EEOC to say that we're going to focus more on advancing majority claims than has been the case in the past. Matter of fact, as many of your listeners probably know, the chair of the EEOC put a post on X saying, if you're a white male and you feel like you've been discriminated against, we may be able to get you some money. something that you would have never seen before from the EEOC. And that's leading to questions about DE and I, or D and I, or whatever everybody, different organizations want to call that. Because the question then becomes, in fact, do these policies, do they adversely impact members of the majority? And so if they're not very carefully crafted, you open up the argument to say this favors a certain group over another group. Usually the favored group is a minority group and the disfavored group is a majority. So you have to be super careful about how you craft the policy, who you involve in the program, and what your goals are. And quite frankly, a lot of this just comes down to what's important to you as an organization. Are these principles part of your culture? Are these things, diversity, equity, and inclusion, are they important to you as an organization? If they are, it's probably worth the work to go in and make sure you're minimizing your risk. Of course, I don't think you can eliminate it, because if you're going to have these policies and you're going to try to advance these principles, there's going to be some risk that comes along with it in an administration and an EEOC that says we're out there enforcing anything that looks like it's disadvantaging members of the majority. So in that case, you really, I think, have to do a corporate assessment of what's important to you and how can you minimize the risk while advancing your corporate policy goals.
That is such a great point, Joe, because it is not about just saying, forget about DEI, I'm done. We know some big employers that have done that and it backfired, right? Because it was this idea of, listen, if those ideals are important to you and they're important to your guests or your customers or your vendors, you really have to weigh that out. I think that's such a good point, and it's so important because the idea of equal employment opportunity and fairness and equality, it is really part of many organizations' mission statements and ideals, and you've got to find a way to balance it with what's going on in Washington. All right, number 3 is also a tough issue, accommodations. There are still limits on accommodations, but the truth is it's complicated. So under the law, as an employer, we accommodate an applicant's or employee's medical condition or disability or religious belief or practice. We don't accommodate their marital status. We don't accommodate their veteran status. All of those folks are protected against discrimination, of course, on the basis of that protected status. Remember, we hear a lot of folks say, oh, well, she's protected or he has a protected characteristic. We all do, right? We all have a race. We all have a color. We all have a sex. We all have a gender identity and a sexual orientation and, a citizenship status, whatever it may be. So the way to think about this with accommodations is to make sure you've got the right processes in place, because we are seeing case after case after case where courts are hitting employers saying, listen, you needed to accommodate this individual. It was not an undue hardship to let somebody work at home, right? Return to office has become a huge source of contention in many workplaces listen, I've been working at home since 2020. Now, 5-6 years later, you're suddenly telling me that I'm not getting my job done? We got to talk about this. We got to figure this out. The most important thing we want you to think about when it comes to accommodations, though, is the interactive process. I just had a very lengthy call with a client this morning about the interactive process. And understandably, this HR professional is very busy, very stressed. And she said, Jen, I just want to send an email to this employee and I want to tell her what we're willing to do and how we're going to do it. And then we're going to see what she says. And I said, no, that's not an interactive process. The interactive process isn't, here's what we're going to do for you, take it or leave it, love the employer, right? We have to do more. We have to engage. We have to talk. Yes, we can send confirming emails, but we have to have a dialogue. And as the employer, you never want to be the one who has stopped the dialogue. You always want to be the one that is continuing, that is giving more suggestions, more ideas, more ways that you can solve the problem. As I like to say, you treat these folks like they are your favorite employees every single time. What would you do for your most favorite employee? That is what you do to accommodate this individual. And if you see a disconnect between what you would do for your favorite employee and what you want to do for this person, take a step back, right? You've got to think about it, because as we talked about a few weeks ago with the Liberty Mutual verdict down in LA, juries care about what actually happened. They care about the outcome, right? So you have to figure out, if you're not going to accommodate somebody and that means they can't do their job, that's fine, but your I's better be dotted and your T's better be crossed. All right, number 2 on our list, Joe, internal complaints. All right, how can an internal complaint create liability all by themselves? How does this even happen?
Well, it's a great question. So there was a key ruling that was issued last year that raised this very important question of when are employers required to investigate internal complaints. Now, Jen, in my opinion, HR people are doing more and more investigations than ever before. It's become such an important part of their jobs. And you and the folks at Shaw Law Group have this great 3-day investigation seminar that you do that everybody could benefit, including me probably, from participating in that. But it's become such a big part of HR professionals' job. And if it isn't done right and to the expectation of the courts, you can be looking at significant liability situations. And at the webinar, we talked in more detail about this case, and it's really got some salacious facts associated with it.
Sure
but
does.
we have an employee who went out on a leave of absence, another employee who had an interest, a romantic interest in that other employee, and tried to express that interest in some perhaps unfortunate ways. But all that occurred while the gentleman was on leave. And when he came back to the company, then he complained about this behavior that had been occurring. The company sort of said, well, you were on leave at the time. You were early at work. We don't really need to look into that. And we're not really going to do anything to protect you from this person who had previously expressed this interest towards you while you were on your leave. Well, that didn't work out too well for them, because the court said, even though the company was right that they're not responsible for what a coworker does while an employee is on a leave of absence, they're not right that when the employee comes back and complains about that behavior, that they could just walk away from it. They can't. They just can't walk away from it. They have to look into the allegations. They have to assess whether or not the alleged behavior might have an impact on the workplace currently, and then take action to make sure that they avoid any further offensive behavior. And that didn't happen in this case because the employer misunderstood its obligation.
That's right, Joe. They just didn't know what they were supposed to do. And as we talked about a moment ago, and we mentioned in the webinar last week, everyone has to be on their toes when it comes to these complaints, right? In California, we have a separate cause of action for failure to prevent harassment and failure to properly investigate these kinds of complaints. So it's not the kind of thing you can ignore. And honestly, that's why it was number 2 on our list. It's a pretty big deal. Now, number 1 on our list is something we talked a lot about on the webinar, which is documentation. All right, now, a couple of weeks ago, again, we talked about Liberty Mutual, that verdict down in LA, and we said, look, documentation wasn't enough. In that case, there was some data, some statistics that really sort of trumped, if you will, what was going on with that documentation about why they decided that this employee needed to be terminated. But that verdict aside, documentation is always going to be your best defense. One of the things I like to say is, if it's not written down, it did not happen. Do not tell me that you told this employee 47 times not to do what they just did, and that's why you fired them, if none of that was written down. I don't care if we're talking about wage hour claims, accommodation requests, internal investigations, as Joe just mentioned. Documentation is everything. You can do a perfect investigation, but if your report is written on a Southwest napkin, which I actually had, that doesn't look like you really took the time to do a thorough investigation. You may have reached the right result, but the process is going to be questionable. So think about what your policies and your practices and your protocols are. Then should be something that is easy for people to do. Make it possible for your managers and your supervisors to take notes, to let you know when something's going on in HR. It's so important not to create protocols that are overly burdensome or take too much time or too hard to understand. We've got to make things easy, right? And the documentation has to actually contain the information you need, right? We're back to that who, what, when, where, why, and how. And when you document something, you don't document just your side of the conversation. You also have to document what the other person has said. So each of these top 10 items could be an hour-long webinar on their own or even longer. But what Joe and I wanted to do for you here today is help you take some of the nuggets that we talked about during the webinar last week, which of course, remember, you can get on the website, so you can go listen to it again at EmployersLawyer.com and distill them for you in a way that you can almost make a checklist, right? You can go through here and you can figure out, all right, for 2026, what's my to-do list? Let's look at each of these issues and let me figure out where my opportunity areas might be. The reality of the situation is, folks, is not the year to wing your compliance. You cannot just think, well, tails, I'll do this, heads, I'll do that. I'm sure it'll all work out. It just doesn't, right? And Joe and I have really tried to give you some just basic bottom line advice and information here today. I want to thank you, Joe, so much for coming back on today. I really appreciate it. It's so much more fun to do these with someone else. So thank you so much for coming and for giving us all your wisdom.
Always a pleasure. I'd be happy to come back anytime.
Well, thank you. And the rest of you guys, listen, if you're leaving this podcast today thinking, gosh, I might have some things I need to clean up, I think you might have some things you need to clean up. Don't panic. We can do hard things. We know that. We've talked about this on the podcast since we started it, years ago. Keep focused on what you need to do. Take it one step at a time. Try not to get overwhelmed. You can do this. We're here to help you. Thank you so much, everybody, for joining us here today. Go out and have a great day. Do something nice for someone, and we'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. Thank you for joining me on this episode of Workplace Wake Up. If you found today's discussion helpful, be sure to subscribe, leave a review, and share the podcast with your HR and leadership teams. For more insights, training programs, and legal updates, you can visit us at shawlawgroup.com.